Guys, called the case of Arbor Commercial Realty versus Scott Sendes.
Good afternoon, Your Honor. For the record, Tim Dubowski appearing on behalf of the plaintiff, Commercial Realty, LLC.
Scott Sendes, Your Honor.
All right. And where are we on this, Tim?
Well, I thought we were going to be able to resolve this, but we were unable to, so I guess we're going to have a hearing, Your Honor.
The moment court comes to order, it's clear this won't be a routine hearing. Tenant Scott Sendes is asking for 6 months to vacate a commercial property, a request that immediately raises eyebrows. On the other side, landlord's attorney Tim Dubowski isn't budging. He counters with a firm offer, just slightly more than the standard 10-day eviction period. What follows is a legal standoff, urgency versus delay. Sendes argues there was a verbal agreement: if he moved out, he wouldn't owe any back rent. But in the world of commercial leases, verbal agreements rarely stand without written proof. Dubowski flatly denies such a deal ever existed and points to the obvious fact: the tenant is still occupying the space. The judge leans forward, already sensing the complications ahead. Courts deal in contracts, not conversations. And as the back and forth continues, the tension builds. Each side is entrenched. There's no signed agreement, and no sign the tenant is preparing to leave. Just words, frustration, and growing doubt. The judge walks a tightrope, balancing patience with the legal limits of leniency. With every claim, the line between honest misunderstanding and calculated delay gets harder to see. The stage is set. One party wants more time. The other wants their property back. The courtroom is heating up, and Richard is just getting started.
6 months to move all of the stuff out, that's one issue. And I told him that we can't provide him 6 months. We can give him a little bit more than the 10-day statutory period. And the other thing is that he feels, for one reason or another, that there was an agreement that if he moved out, which he still hasn't moved out, that he didn't owe any back rent. Did I accurately?
The judge wastes no time cutting through the noise, swiftly dividing the case into two separate issues: possession of the property and unpaid rent. It's a sharp, strategic move that clears up confusion and zeroes in on the legal core. Even if there's a dispute over back rent, the judge makes one thing clear: eviction can proceed based solely on possession. That distinction is critical. The tenant, Scott Sendes, believes the back rent could be waived based on a verbal agreement. But the judge isn't entertaining that idea, not while Sendes is still occupying the space. Time and again, the judge reinforces the point: regardless of any financial disagreements, the tenant must vacate. Sendes insists he's in the process of moving out, but vague intentions don't carry legal weight. Saying you're leaving isn't the same as being gone. The judge won't entertain circular arguments. While acknowledging the tenant's position, he draws a clear line: if you're still there, you're not in compliance. Simple as that. In commercial real estate, timing is everything. Delayed possession affects the landlord's ability to re-rent the space, and the court understands that. The judge's tone grows firmer: he's not looking for sympathy or stalling tactics. He wants hard dates, not hopeful guesses. This isn't about feelings. It's about legal timelines, written agreements, and respect for due process.
I would no longer be paying the rent. I told him I couldn't pay the rent and move out. And I thought we had come to a mutual agreement that it would be best for both parties if I just moved everything out.
And it's my client's position that no agreement was made, and even if one was, the client still hasn't moved out and still wants another 6 months to move out, Your Honor.
So you're not disputing that the rent's owed, right?
Well, I am, because I had an agreement with the landlord to, if I moved out, in lieu of paying the back rent.
Which he hasn't moved out, even if there was an agreement.
But I'm in the process of moving out.
But really, guys, I hear you. you guys can keep repeating it, but
I'm sorry, Your Honor.
from one moment to the next. I get it. So, I mean, there are two parts, so that you understand this, sir. There are two parts of this case. One is the possession issue, and then the monetary issue. In terms of the possession issue, I don't see that there's an issue for me to try, because the condition of you staying is, first of all, to pay rent. Even if, I'm not saying that I'd make a finding that there is, even if there is this other agreement that you move and you don't owe the rent, the only bearing that has on the possession issue is
The tenant makes a final plea for understanding, asking the court for 6 months to vacate the warehouse, citing the sheer volume of inventory still inside. He even proposes hosting a liquidation auction to clear it out, though he admits securing a loan to fund the process could take 2 months or more. While he tries to present himself as cooperative, offering to pay for junk removal and leave the property clean, the court isn't fully buying it. To the judge, this sounds less like a plan and more like a delay tactic. Then, a twist, the tenant reveals he wasn't aware that the person he made the verbal agreement with no longer manages the property. That's a serious problem. In legal terms, agreements must be made with someone who has actual authority to bind the landlord. If the deal was made with someone who lacked that power, it's void from the start. That revelation severely weakens the tenant's defense. The judge is now clearly concerned, not just about the delay, but about the confusion and lack of formal agreements. The courtroom's focus shifts back to the central issue, possession. Time is ticking, and the judge doesn't intend to let this drag out unnecessarily. It's evident the court is looking for resolution, not indefinite negotiation. The 6-month extension is off the table. And the tenant? He's running out of room to maneuver.
deal with just the possession issue and then set it for a further hearing as to the money claim. But if I do that, then the question is when are you going to move? Because I think they'd be entitled to a judgment for possession. And the reality is that if I do that, finding no tribal issue on the issue of possession, it's going to be 10 days. I can tell you that even using my discretion, I wouldn't give you 6 months to move. So if we just deal with that part of it, when can you be out?
I mean, I said realistically 6 months because there's so much stuff. I understand that that's not agreeable with them, but I've tried to work with them. I even offered another solution to conduct a liquidation auction, but I said even that's going to take, probably 2 months realistically, and everything still won't sell. So I did make a promise that I would clear the property out in lieu of not paying rent, and I would make sure that it was, left empty. And that's why I came up with the 6 months, because I know that's still going to take time. Even after I liquidate a vast majority of the stuff, it's still going to take time to remove the junk. And I'm willing to pay for the removal of all the trash that's in there and leave it empty. But I don't think that's agreeable.
Well, they've said it's not agreeable.
The other problem I'm having is I just found out recently, a few minutes ago, that the person I've been dealing with apparently is no longer the owner of the property. So the person that I've been dealing with, the person that I had a verbal agreement with, I guess is no longer, making the calls, and I was not aware of that, which I guess explains why I haven't heard back from the person that I had made this deal with.
The landlord's attorney steps in to clear up the confusion. Ownership hasn't changed. The tenant was likely speaking with the owner's son, someone without legal authority to make binding agreements. That, the attorney says, is where the misunderstanding began. The tenant admits he didn't know who had actual decision-making power. And that's exactly why courts rely on verified, written agreements, not assumptions or hearsay. He insists he was told the rent would be waived if he agreed to move out. But once again, the judge cuts through it. You haven't moved out. No move means no rent waiver. It's not about fairness or intentions, it's about contract law. The tenant pushes back, claiming he's in the process of moving. But the landlord's attorney doesn't let it slide. That process could go on forever. Everyone in the room acknowledges the property isn't small, it's a 10,000 square foot warehouse, not a studio apartment. But the court doesn't deal in logistical sympathy. It deals in outcomes. And as far as the judge sees it, the tenant is still occupying the space. Intentions don't count. Actions do. The judge's patience is starting to wear thin. This isn't about delays, promises, or misunderstandings anymore. It's about compliance with the law, and right now, the clock is running out for the tenant.
Speaking to that aspect only, the owner's still the owner. The son has been managing the property for the last year or so. So, I don't know I think that's what you're referring to.
I guess I just meant I wasn't aware that the person that I was talking to isn't actually running the operation anymore. So when I was told, I won't charge you any rent if you can move everything out, and at the time I talked to him last, I didn't give him a time.
That's, again, the problem with that is, if I assume that's true, you haven't moved.
I'm in the
Which
process.
means if you haven't moved, that means you still owe the rent. Right? Which means they'd be entitled to a judgment and you'd still owe the money.
But the agreement that I had was that I wouldn't be paying anymore if I moved out.
But you haven't moved out.
Correct. I'm in the process of moving out.
Well, according to his own words, Your Honor, that's a 6 months ordeal. So, I could say I'm moving out of my house by taking a dish at a time.
Well, this isn't a one bedroom apartment. This is a 10,000 square foot warehouse packed to the rafters with stuff. So it's not, it took several years.
I get back to my same question. For you, how much time are you looking at? 6 months is not going to happen.
Okay.
So, here, just let me finish this. The statutory period would be 10 days.
Right.
I get the circumstance that you're in, so maybe that's not realistic that it's the 10 days.
Right.
But I can tell you that even if I use the furthest reaches of my discretion to give additional time, it's not going to be near 6 months.
Okay.
And so if you guys can't decide, I'm going to pick a date on the possession issue, and then I set it for trial on the monetary issue. But you guys are going to have to decide. It's going to have to be something realistic, sir. They're entitled to the possession of their property by even what your agreement was. They're entitled to possession.
I can guarantee I can't move everything out in 10 days. It's not.
What would be the fastest?
4 months. Is that agreeable?
No, that's puts us in the same position.
It's like I said. I probably moved half of it out within the past 3 months.
The judge finally steps in, firmly, and says what everyone's been thinking: 6 months is not happening. He's open to granting more time than the standard 10-day eviction window, but not by much. The court won't allow a commercial property to sit idle for half a year while negotiations drag on. The tenant pivots, now asking for 4 months, calling it a realistic timeline. But to the landlord's side, it sounds like another delay dressed up as compromise. The judge acknowledges he has discretion, but makes it clear, even with flexibility, 4 months is far too long. It's a standoff. The tenant admits he's managed to move out only half of his inventory in the past 3 months, yet now wants 4 more. That pace simply doesn't add up. The landlord's attorney pushes hard for immediate possession, arguing that delays are costing the owner real business opportunities. The judge agrees. Something has to give. And if the parties can't resolve it, he will. He reminds the courtroom that the landlord has a legal right to reclaim their space. If there was no written agreement granting extra time, then possession cannot be postponed based on informal conversations or hopeful timelines. The message is unmistakable: stalling ends now.
listen to everybody. As to the issue of possession, we're going to find that there's no tribal issue as to the issue of possession only. I'm going to issue an order of eviction on or after June 30th.
After what, June 30th, Your Honor?
Yes, June 30th.
Thank you very much.
I will also, on the damages and money issues on the case, I'll set a trial on that matter for July 15th, 2025 at 9 a.m.
Thank you. And I will prepare the order on the possession. I'll submit it to the court. I'll submit a copy.
Will I be getting a copy? Because that's the other thing. I haven't received any court summons or anything.
Well, we have a proof of service in the file here.
What do you mean you haven't received any summons?
The only summons that I received was the one on the tape to the door, and
That's service.
I was under the impression that I was also supposed to be mailed something as well. The one that was taped to the door had the address in Saline, which is why I wasn't here at noon, because I went to the courthouse in Saline, and they said, "Oh, you're at the wrong place." And then I called the number that was on
The judge delivers his ruling. There is no legal barrier preventing eviction. He orders that possession of the property must return to the landlord after June 30th, giving the tenant only a few weeks to vacate, far less than the months he had requested. As for unpaid rent and potential damages, the judge schedules a separate trial for July 15th, making it clear that the eviction issue will not be delayed any further by financial disputes. The tenant appears caught off guard. He asks whether he'll receive anything by mail and claims he was confused about the court address and the details in the summons. But the judge is unmoved. Proof of service is on file, he explains. Whether delivered in person or by mail, it was valid and proper. The tenant continues to raise last-minute concerns, but it's too late. Judgment is being finalized, and a copy will be sent to all parties. The court has spoken. The eviction clock is now officially ticking, and the rent dispute will be handled in its own time. Justice was served, by the book.